Not very good, to be honest. Right, well, just a sec, Jim. Right, so what I need is a contact at the magistrates court, because all the letters I've been sending basically have not been replied to. And obviously, is it a legal advisor that helps me, or would it be you that I would speak to?
Well, first of all, there's limits to what I can advise you on, because I'm the manager of the legal advisor, so I am their boss. And I have already responded, if you recall, to I think at least one, possibly two of your letters.
No, just one, and you said you didn't want to discuss anything.
Right. Well,
so that's not really helpful, because the issue I've got is that I've got a summons now.
Yes.
And basically, I need to speak to somebody who will respond, because obviously, as I'm representing myself, the clerk to the justices has got I want some questions answered.
Well,
because obviously, because I'm representing myself, I know nothing about the procedure.
I've rung you this afternoon in an attempt to assist. So if you want to ask me a question about the procedure,
right? Well, I would rather put this in writing, because I want you to define some terms, like summons, etc. The actual legal definition of it.
I can tell you what a summons is. A summons is a document that directs you to attend before a court.
Right, and under which law is that? Because I'd need that in writing if possible, Jim.
Magistrates Courts Act is the power for the magistrates to court to issue a summons.
Right, so what's the actual definition of that word, though, summons? That's what I want to know. From the Black's Law Dictionary.
A summons is a document which directs a person to attend before the court. That's the
definition. But that doesn't actually tell me the definition of the word itself.
I'm not going to. I can't define.
You can't define words, so basically you're saying that you've sent me a summons, and I'm asking what the word means, and you can't tell me.
You are summoned to appear before the court. It's a court summons, and that court summons directs you to attend before the court. So if you like, it's a written form of a direction, if you like.
Yeah, I understand that, Jim, but I need to, because you obviously read the Black's Law Dictionary, haven't you? Because you've got legal training, yeah?
I have got legal training.
Okay,
yes.
so I would like to know the actual definition of the word, because it means invitation, if you look in the Black's Law Dictionary.
I'm not going to
That's what it means. I'm not arguing semantics, Jim.
I won't be responding in full to letters if you're going to be asking me those sort of questions. But
right, I'll tell you what, right, what I'll do, Jim, I'll write to you, and I'll write a list of questions down.
All right.
And then basically, you can decide whether you're going to answer them.
I think that's a jolly good idea.
Okay, so I'll do that.
But obviously, my attention personally?
Yes, I will, Jim. But obviously, what I'm trying to say is that because my name is Crown property, the Queen actually owns my name, and obviously because my parents registered my name at birth, registration means given away, so I can't possibly represent that name without committing fraud. You see, this is what I'm talking about, and I can send you all the evidence, all the details, because a birth certificate is a bond, Jim.
I will not get involved in correspondence with you.
Jim, they're not concepts; it's a truth. And the thing is, with you being the head of the legal manager at Hull Magistrates Court, obviously you need to assist me because I'm unrepresented. And what I'm doing is I'm looking at this system and I'm seeing it for exactly what it is. Because basically I've caused no harm, I've caused no damage, I've not got a contract with you, and basically a summons does mean invitation and must means may, and I'll get the definition for you, because I've read it in the Black's Law Dictionary.
I will not be responding in detail on concepts that you have raised.
No, but I'm actually going for. Hang on, Jim. Let me finish, because you do need to help me here. I'm not represented, and you do have a duty to do that. It's in your guidelines.
I have a duty to assist an unrepresented defendant in the courtroom
as
best as I'm able. You send your letter to me and you pose the questions. I'll obviously take careful consideration of that, and I'll answer the questions.
Well, you need to, but the concept I'm trying to get over is there's a massive conflict of interest here. Because basically, I could say to you, who are you representing, Jim?
I don't represent anybody.
You don't represent anybody.
My role is to advise the magistrate.
So you don't represent the Crown in any way, and obviously you don't direct them to say to them, yes, that is the name, that's not a legal fiction. Because obviously, with the letters I've written to you, I've never ever said I will represent that name, because that's where the fraud is, Jim. And it's not just me that thinks this, it's actually the truth, and a lot of people are waking up to this now. Now, another question I'm going to put forward to you is, are the magistrates actually aware of where they're sitting, because they're boxed off, they've got no legal or lawful training, and they're being directed by you. You know, and obviously I can say to the, you know, because I've got a full dossier I'm going to give the magistrates, and obviously I've looked at the guidelines, you can't be adversarial, you've got to help me, and this is how I want to present it. I'm not going to represent that name.
All help that we could possibly give you will be provided to you, an unrepresented defendant, because that's part of our duty.
It is.
In the job that we fulfil.
Yep, so basically, because you're aware of my position now, you can't just suddenly say to me, well, I'm not going to get into semantics with you, because what you're doing is, by sending out a summons in the name that the Crown owns through the birth certificate, you're asking me to commit fraud. I cannot possibly represent that name. And I never has.
You send me your letter and I'll do my best to respond to it as fully as I possibly can.
I've got no confidence in that, Jim, because all the letters that I've sent you before, you've not responded to.
And I'm not going to enter into any more correspondence or any more discussion with you. You send me your letter.
Right, can I just ask you a question then, Jim? Because obviously you wanted me to come to this invitation on the 8th of January. Now that's not possible. I can't come on that date. So what I'm going to do is I'm going to write in a letter that I can't come on that date.
Okay.
But obviously I'm also going to put in actual evidence of what I'm saying, Jim, you know, because it's really not right. Okay, so going on to the court matter. No, Jim, can I just finish? Jim, I haven't finished. Please let me finish. So basically, when we go into the court, into this invitation, it can't be on the 8th of January, but when I do come in, I will want to be able to say what I'm saying to you now without any interference or any interruption, because basically you're only there to advise them on points of law, and I want to get across to the magistrates, like I say, that are boxed off, know nothing about this. I want them to know what's going on, because basically they're the fall guys who are signing the warrants at the end of the day. And
what I would ask you to do, please, is set out very carefully.
Oh, I will.
Can I just finish, because I've listened to you?
Yes, Jim. Yes. Carry on. You have my permission.
Thank you. If you set out very carefully and clearly in your letter why you're not going to be there on the 8th.
No, I am going to be, Jim. I am going to be there on the 8th.
I'm sorry. I thought you just said you won't.
Oh no. I can't be there on the 8th. But obviously we're going to have to rearrange this invitation, because obviously it's.
I'm sorry. You're not listening to me. With respect.
I am listening.
Your first date of hearing is.
Yes, and I can't make that one. I will write that in the letter.
Would you please set up, because, and this is in part of the process of trying to make you fully aware of this.
Okay, Jim. Yep.
Is that if you don't attend and you don't respond to the summons.
Oh yeah, I know what you'll do. You'll just plead guilty for the strawman that you've got, because you did that last time.
The court is able to deal with the matter in your absence, and the court is able to do that unless there's good reason for you not being there, and I want you to be aware of that so you can set
Right,
that
so I mean basically my reason is that because I'm representing myself, I need time to prepare. It's coming up to Christmas, okay? I can't spend all my time on this. It's ridiculous. So obviously I need time to prepare. I need time to transcribe the evidence that I've got, you know. And I want to be able to make sure that when I come there, I'm not representing the name. I'm coming to basically show up the fraud of the name. And I don't want you to think, obviously, that this is personal. It's not, Jim. I'm frustrated. Because at the end of the day, I'm not pepper bombing Baghdad. I'm not running amok. I'm not starting wars. I'm not hitting people. You know, I'm not acting like a crazy person. But I'm being made. But the thing is, I'm being made to feel like a criminal, and I'm not a criminal, Jim. And
suggesting that you are.
oh, you are suggesting that I am. You've sent me a criminal summons. It's a criminal matter. So basically, that's you saying you're a criminal. You know, you'll represent this name.
No, I'm sorry, I don't agree with that at all.
Well, that's okay, Jim. Just as long as we can rearrange this date, I'll come to the invitation. Obviously, it'll be under duress and a special appearance. I'll have to charge for it as well. And I will put in front of the magistrates exactly what's going on. I'll tell them exactly why I won't represent my name. But obviously, I don't want to be barred from doing this by the legal advisor, because you know you can't be adversarial. You've got to treat them with mutual respect, and obviously I want to get across what I want to say. Now, another thing I want to ask just before you go, Jim. Mrs. Leila Viggers was the legal advisor last time. Now I've written to you and I've asked you this question. I just want to know why, when I asked the magistrates under oath a question, she told them not to sit under the oath. Now, as far as I understand it, a magistrate has to sit under oath to actually take up the office, to have the authority.
The magistrates are not there to answer your questions with respect.
Ah, right, okay. No, with respect, what I need to do is, obviously, because I'm representing myself, I need to speak to the magistrates, and the magistrates need, obviously, because that's the whole point, you know, of me coming to this business meeting, to speak to the magistrates.
It's not a business meeting, it's a court
Oh dear. So basically, all I'm
You send me your letter.
Jim, all I'm trying to say, and I want to ask a question. I want to know why Mrs. Viggers told the magistrates not to sit under their oath. Why was that? All I basically said to him was, well, I'll run it by you. I said, under oath, full commercial liability and penalty of perjury. Are you a company, and will you help me sort this out today? Now, when that happened, straight away she ran up to them. She said, no, you're not under oath. You know, which is perjury. Obviously, they've got to be under oath. The magistrates.
Of course they haven't. Of course they haven't.
They haven't got to be under oath. So, yeah, well, that's why I'm asking you, Jim. Tell me how the oath operates. These are the things I want to know.
They've taken an oath as their appointed magistrates.
Right. Okay.
When they're first appointed as magistrates, they take an oath.
All right. Okay. And how does that operate?
Well, I don't understand the question.
Okay. The question I'm asking you is, are the magistrates actually operating under their oath when they're sat down in that chair, in that bench?
Yes, they've been appointed as magistrates.
Right. So they're operating under their oath then, yeah?
Yes.
Excellent. That's all I wanted to know, because the thing is well, obviously I'm going to lay it out to you when I write to you. They can't possibly sit under that oath with the questions I'm going to ask them, because there's a conflict of interest. It's a company. I bought your company report as well, you know, so basically I've got your supplier report, you're listed as a company, and it's in black and white, you know.
Those are issues for the court when the court deals with the matter, maybe not at the first hearing, but subsequently at the trial. You send your letter to me, madam, and I'll do my best to answer all the points.
The thing is, Jim, what I want to make sure is that you just don't railroad this, and you do listen, because
I'm not going to comment on that suggestion. I have assisted you as much as I possibly can this afternoon.
Okay, well, that's brilliant that the magistrates.
I will do my very best.
It's really good news. Okay, Jim.
I'm going to draw this conversation to a close.
Thank you for letting me know the magistrates sit under their oath as well.
Thank you very much.
That's excellent information. I love you, Jim. I'll see you soon.
Thank you.
Bye-bye. Mwah. Gotcha.